Thank you, Speaker, and I'm proud to speak in support of this particular bill. And I thank the Minister and the staff for crafting this very common sense bill and bringing this bill to the House. Victim registers play a crucial role in supporting victims of crime by providing access to specific information about the offender, including release dates and changes in their legal status, and allowing some victims to make submissions for consideration during key events, such as an inmate's release on parole. I'm proud to acknowledge that the first Victims Register here in New South Wales, operated by Corrective Services, was established by the Carr Labor government in 1996. The Corrective Services Register is for victims of adult offenders and is constituted under the Crimes Administration of Sentences Act 1999. Victims who are eligible to be registered include a victim of an offender serving a sentence of imprisonment by full-time detention, a victim of an offender serving an intensive correction order for a personal violence offence, a victim of a high-risk offender, a victim of a terrorism offender. Interested persons may also apply to be registered on the CS New South Wales Victims Register. And the legislation provides a non-exhaustive list of persons that may be an interested person, and includes anyone the Commissioner is satisfied is reasonably expected to have his or her life or safety endangered because of his or her connection with that offender. This may include persons who have a connection to the offender due to a prior harm or violence, a domestic relationship, or being a witness or being a victim of a previous serious offence or offence of a sexual nature committed by the offender. Family representatives of a victim must be recorded instead of a victim if the victim is deceased, under incapacity or less than 18 years old. The Corrective Services Commissioner may direct that a 16 or 17-year-old be placed on a victims register instead of their family representative after considering the victim's circumstances. Victims and interested persons may also nominate representatives to act on their behalf and receive information from the CS New South Wales Victims Register. A victim includes a person who, as a direct result of an act committed or apparently committed by an offender or high-risk offender in the course of an offence, suffers actual bodily harm, mental illness or nervous shock, or has property deliberately taken, destroyed or damaged. Once again, a victim is registered on the Corrective Services Register. They receive notices about the offender, including information about the offender's sentence, release dates, or changes in their legal status. For example, a registered victim may receive notices about a proposal for the Serious Offenders Review Council to recommend a low security classification for that offender, the State Parole Authority intending to grant parole for the offender, if the offender is due for consideration of whether they should be released to reintegration, home detention or on parole, or is eligible for or has applied for release on parole. Registered victims and interested persons will receive notices if certain orders are made in respect of the offender, such as a reintegration home detention order releasing the offender, a parole order releasing the offender on parole. Information will be provided about the date of the release and any additional conditions placed on the reintegration.
Excuse me, member. The member has called for a quorum call, so we call for a quorum. Just take a seat.
Is it a quorum?
It wasn't even planned.
A quorum has been established. Thank you, members. Apologies for the disruption. Member for Penrith, I hope you can regain the position. I recall the member for Penrith.
Justin, that's your quota for the year. That's it.
Thank you, Speaker. And I will just reiterate where I was previously in my speech. So the registered victims and interested persons will receive notices if certain orders are made in respect of the offender, such as a reintegration, home detention order releasing the offender, a parole order releasing the offender on parole. Information will be provided about the date of the release and any additional conditions placed on the reintegration, home detention, or parole order. Notice will also be provided if the conditions of the reintegration, home detention or parole order are changed or if the order is revoked. The Corrective Services Commissioner may also provide other information to registered victims and interested persons as is relevant, and that includes any change to the offender's earliest possible release date, if the offender dies while serving a sentence or released on parole, the name of the correctional centre in which the offender is serving a sentence, if the offender escapes while serving a sentence, the offender's security classification and any changes. A decision by the Commissioner to issue a local leave permit for the offender, the exercise by the Governor of the prerogative of mercy in relation to the offender. I may have mispronounced that. If the offender is transferred into the custody of another state, a territory of the Commonwealth. For victims of high-risk offenders, if the offender is subject to an extended supervision order or continuing detention order under the Crimes High Risk Offenders Act 2006 or the Terrorism High Risk Offenders Act 2017. If the offender is taken into custody while on an intensive corrections order, where the intensive correction order is in relation to a personal violent offence. This information helps victims and interested persons understand the custodial framework under which the offender is supervised. Speaker, I ask for an extension of time at this point.
The member requests an extension of time. Is time granted? Yes, it is. Thank you, member.
Thank you. This knowledge is vital as it gives the victims knowledge about the processes and timelines involved in the offender's sentence. By having this information, victims can better navigate the justice system and feel more in control of their particular situation. By being informed about the offender's status, victims can take necessary steps to plan for their safety and well-being. This proactive approach is essential in helping victims feel secure and supported. Knowing when an offender is due for release or if there are changes in their legal status allows victims to make informed decisions about their own safety measures. These notices also advise victims of their availability to make submissions for considerations during key events. For example, registered victims are notified that they can make submissions for the consideration of the Serious Offenders Review Council if a low security classification for a serious offender is recommended, the State Parole Authority in deciding if the offender should be released to reintegration, home detention or on parole. These submissions allow victims to express their views and request conditions they feel should be imposed on the offender if leave or parole is granted. This supports the principles of therapeutic jurisprudence by allowing a victim's voice to be heard when relevant decisions are made. Speaker, I believe that this bill has a very common sense approach which will go to some considerable way of giving reassurance to victims in their particular situations, and I commend the bill to the House.